โอ้ยพี่อ้อยพี่ช็อตไม่อยู่ยึดห้องจัดรายการเป็นของเราคนเดียวแฮปปี้ครับ
ก็ได้โอ้ยอะไรกันเนี่ยแค่นี้นะ
อะไรเนี่ย
อารมณ์เสีย
โวยวายเสียงวีนมาแต่เช้าเลยเธอ
จะไม่ให้ฉันวีนไม่ให้ฉันเหวี่ยงได้ยังไงจ๊ะจ้างช่างมาต่อเติมบ้านนี่เลยสัญญาส่งมอบมา2 เดือนแล้วยังไม่เสร็จเลยแล้วไงรู้ปะทำผิดแบบอีก
เอาก็ให้เขาแก้สิ
แล้วพอบอกให้ลื้อไงลื้อไปทำตามแบบจะมาคิดตังค์ฉันเพิ่มบ้าหรือเปล่าคิดตังค์เพิ่มอะไรไม่ได้นี่นะถ้าไม่ใช่คนรู้จักแนะนำมานะฉันจะฟ้อง
เดี๋ยว
ขึ้นโรงขึ้นศาลให้เข็ดไปเลย
ไอ้ขึ้นโรงขึ้นศาลแล้วฟ้องเนี่ยได้ยินมาเยอะแล้วมันอาจจะสะใจแต่ถ้าทำไปจริงๆนะเสียเวลาเสียเงินเสียทองเยอะมากและบางทีคดีจบคนไม่จบนะ
แล้วให้ทำไง
ผ่านอะไรมาเยอะมากขอให้เชื่อมีทางเลือกมีทางออกสนใจปะล่ะ
เฮ้ยสนใจ
ถ้างั้นสถาบันอนุญาโตตุลาการหรือว่า THAC เนี่ยเขาเปิดให้บริการระงับข้อพิพาททางเลือกซึ่งง่ายๆเลยคือเขาก็จะเชิญคู่กรณีทั้งสองฝ่ายหรือคนที่มันทะเลาะกัน2 ฝ่ายนี่นะ
สมมติฉันทะเลาะกับเพื่อน
มาเจอกันแล้วก็ตั้งบุคคลที่3มาเป็นคนกลางในการประนอมหรือว่าจะทำหน้าที่เป็นอนุญาโตตุลาการเลยก็ได้ก็คือวินิจฉัยชี้ขาดไปเลยว่าเรื่องนั้นเนี่ยใครถูกใครผิดพอได้ข้อสรุปข้อยุติที่ชัดเจนก็ปฏิบัติตามข้อตกลงนั้นกันไปซึ่งวิธีนี้เป็นวิธีที่เขานิยมใช้กันทั่วโลกแบบเป็นสากลเลยทั้งคดีแพ่งแล้วก็คดีพาณิชย์เพราะอะไรรู้ป่ะเพราะว่ามันสะดวก1 2มันประหยัดเงินประหยัดเวลารวดเร็ว
มีอีก
มากกว่าเวลาที่เธอจะต้องไปขึ้นโรงขึ้นศาลซึ่งโอ้ยขั้นตอนมันเยอะมากเหนื่อยมาก
จริงๆแล้วก็ยังรักษาความสัมพันธ์ที่ดีไปด้วย
ถูกต้อง
แต่ประเด็นก็คือฉันจะไปหาบุคคลที่3มาจากไหน
นั่นแหละเป็นเรื่องที่ยากที่สุดแต่มีคำตอบให้
ครับทางสถาบันจะมีการขึ้นบัญชีบุคคลนะครับที่มีความเชี่ยวชาญและมีประสบการณ์ในด้านการระงับข้อพิพาททั้งทางด้านอนุญาโตตุลาการและการประนอมข้อพิพาทนะครับโดยในบางครั้งทางสถาบันจะมีการฝึกอบรมนะครับผู้เชี่ยวชาญหรือผู้ที่มีประสบการณ์นั้นเพื่อให้แน่ใจว่าผู้ที่มาทำหน้าที่เป็นอนุญาโตตุลาการหรือการประนอมข้อพิพาทจะสามารถทำการระงับข้อพิพาทให้กับท่านได้เป็นอย่างดีครับ
สะดวกนะประหยัดด้วยสามารถยุติข้อพิพาทได้อย่างรวดเร็วดีอ่ะ
ไม่ว่าจะเป็นเรื่องเล็กระดับบุคคลปัญหาการค้าแบบ SME หรือว่าข้อพิพาทระหว่างประเทศก็สามารถให้สถาบัน
不知道。Hello everyone. Could everybody hear me?
Hello, Dr. Chen. Hi, can you hear me?
Yeah.
Yeah, I guess we all can hear you very, very clearly, Dr. Chen. Thank you.
Okay, thank you. So I assume everything is already is okay for starting now. So, good afternoon, everyone. Welcome to join us for the THAC International ADR webinar series 2020.
I cannot hear Dr. Chen.
Yeah.
I cannot hear. What do I do?
Hello, Roland. Roland, could you hear us? 能听得到吗？ Okay. This is the series 8 of this series.
No signal.
No signal. Is that a problem of my side or?
I don't think so, Dr. Chen. I can hear you very clearly. So
Okay, I
think
will
it's
go
not-
ahead. Okay, I will continue. So the theme of this series, today's webinar is how to improve the attractiveness of the place of arbitration, the influence of administrative and judicial policy on arbitration practice. And we are very honored to have three distinguished speakers. First, please allow me to introduce them in the order that we make presentation. Our first speaker is Mr. Gerold Zeiler. Mr. Zeiler is a partner at Zeiler Partners, which is just announced its merger with Floyd Zarkovich to form Zeiler Floyd Zarkovich yesterday. And Zeiler is an expert in international dispute resolution with a strong focus on international commercial arbitration and complex litigation. He has represented clients and served as arbitrators in domestic and international arbitration proceedings, more than 200 at last count, and is seasoned litigator before Australian courts. In 2018, the ICC World Council appointed Gerold as an Austrian member of the ICC Court. He is also listed on the panel of arbitrators of VIAC, SIAC, KCAB, and other renowned international arbitration institutions in Ukraine, Romania, India, and Czech. Gerold is a co-editor of the Austrian Yearbook on International Arbitration, a member of the publications board of ABA section of Dispute Resolution, a fellow of Charter Institute of Arbitrators, and a former president of Austrian Arbitration Association. His published work includes a comprehensive commentary on Austrian arbitration law. He regularly speaks at international conferences and guest lectures university course. Our second speaker is Dr. Roland Amoussou-Guenou, a French nationality originally from Berlin at West Africa. He is a partner at Woven and Associates, and lecturer at various institutes and universities in Thailand and Europe. He is a former member of the Paris Bar Association and former senior legal advisors of the International Development Law Organization in Rome, Italy. Roland Amoussou has more than 20 years of professional experience in Asia as international law expert, senior legal advisor to governments and international organizations. He specialized in international arbitration in ADR and IP law, public-private partnership, and many other areas. Dr. Roland served as a source person for professional training programs on various leadership in management-related topics. It has trained hundreds of senior government officials of Sri Lanka over the years. Dr. Roland is an arbitrator of ICC, member of Arbitration Commission of ICC Thailand, and served as the president of an international arbitration tribunal. Dr. Amoussou is the co-founder and president of Asia Africa Foundations since 2009, and award winner for his contribution in promoting education, cultural ADR, and international arbitrations. Our third speaker is Ms. Céline Aymé-Wauthier. She is admitted to practice in Paris and New York and specialize in international arbitrations. Ms. Aymé-Wauthier started her careers with the ICC International Court of Arbitration in Paris, where she supervised more than 300 ICC arbitration cases involving companies from Europe, Africa, and Middle East. During 6 years, she developed an expertise in complex ICC arbitration proceedings. She thereafter joined the Paris-based law firms, where she acted as a counsel in numerous international commercial and investment arbitration proceedings conducted in English or French. Mr. Aymé-Wauthier moved to Bangkok in 2018, where she now practices as counsel, expert before state courts, and assistant to arbitral tribunals. So let's welcome the three distinguished speakers. And today, as I mentioned before, today's topic is how to improve the attractiveness of the place of arbitration. This is a very interesting topic. So let's welcome our first speakers, Mr. Gerold Zeiler, to share his views on this topic. Zeiler.
Thank you, Dr. Chen, for that kind introduction of yours. So, as already has been said, the topic of today's presentation is the attractiveness of the place of arbitration and how to improve it. I kind of took to present a short introduction into this topic. From time to time, I will a little bit elaborate on the details, but I will try to keep this on a very high introductory level. The starting point here would, I think, be who are the persons, institutions who are in a position to improve the attractiveness and the quality of a place of arbitration. And thinking about that, I could identify a number of key players, which I listed on my first slide. And these key players, that would be the legislators of different countries, who of course have a great influence on the attractiveness of a place of arbitration, but also, and I will explain that later, I think very, very importantly, arbitral institutions, and also the practitioners situated in a certain place of arbitrations, and the law schools at that place of arbitration, because they will educate a huge number of practitioners who will conduct arbitration proceedings at that place of arbitration. And last but not all, the fourth major player here, I guess, that would be the governments of the places of arbitration and the infrastructures they provide for. And I will now try to go through this list of key players and to explain a little bit about why I identified exactly these players in the field. Let me start with the legislators. Now, what we hear time and again is that a place for arbitration is attractive if that place is arbitration friendly. Yeah, it's an arbitration friendly jurisdiction. Now, what does that mean? Now, does that mean that everything is allowed, everything is doable? Probably not. Does that mean that that this is a heavily restricted place where only little is doable? Probably neither. So it has to be somewhere in between, because if everything is doable, that's not helpful for arbitration proceedings. There has to be a number of rules which assist, which regulate arbitrations. The usual model, of course, is the arbitral model of international commercial arbitration, which has been adopted by a number of countries, which has become, so to say, the gold standard. It never hurts, I would say, if a party introduces that arbitral model law. It has also the advantage that a number of international arbitrators will be in a very easily will be in a position to arbitrate in that country or to represent parties in an arbitration in that country, because they will be familiar with the arbitral model law. They will be, if there is an English translation of the local law, they will easily be in a position to read the text, to understand the law in the place, and will be able to work. If the law is completely different from the arbitral model law, it's much more difficult for international arbitrators to become active in that jurisdiction. It's helpful if a lot of people are in a position to arbitrate in a place. But I will come back to this a little bit later again. A couple of things which came to my mind when I thought about the quality of a place of arbitration. Court interference. Now, court interference, of course, that comes always as a bad word. There shouldn't be court interference. At least there shouldn't be too much court interference. But thinking about it, that's not entirely true, I guess, because some level of court interference is quite important for a place for arbitration to work. Think about the appointment of arbitrators. Unless there is an institution which does the job, there is also still a lot of ad hoc arbitrations going on. So to some extent, you will need courts to appoint arbitrators if a party to an arbitration agreement is not doing what they should do, that is to appoint their arbitrator in an arbitration. So court interference is not always a bad thing. It can be a bad thing if it comes to anti-arbitration injunctions, for example, where there is a valid arbitration clause. On the other hand, an anti-arbitration injunction where there obviously is no valid arbitration clause has been concluded between the parties, is that necessarily a bad thing? Probably not. So court interference can be both, and the right level of court interference is also, if it comes to challenges of arbitrators, for example, if there is no institution involved, or even if there is an institution involved, it might be a good idea to have the courts to have the last say in that respect. So it's not always a bad thing if courts interfere. It has to be the right degree. Finding that out might be difficult. Reading a look into the arbitral model law on international commercial arbitration may be very helpful in that respect. Next point, which came to my mind, annulment proceedings. Very important. Arbitration wouldn't work without annulment proceedings, without the possibility to annul an award in very grave and serious situations. On the other hand, if it's too easy to annul an award, that's hurtful for international arbitration as well. So in order to be an arbitration-friendly place where arbitration prospers, again, the right degree of regulation is important. One issue might also be, what are the costs of annulment proceedings? Now, one story from the jurisdiction where I've been primarily educated, that is Austria in Europe, there is in 2013, so only a couple of years ago, a new annulment regime has been introduced, which is a perfect fit because an annulment claim has to be brought immediately before the Austrian Supreme Court, and there will be a specialized chamber dealing with the issue, which has a lot of experience in arbitration. So very good development, very helpful for arbitration. At the same time, not that helpful at all, but I have to add it, the costs for an annulment claim, if you want to bring it, are 5% of the amount in dispute. So that can be a very, very high amount, which sometimes makes it difficult for a party, overly difficult, I might say, to bring annulment claims before Austrian court. So not that good a development. But the bottom line of that probably is costs should not be too high. Access to annulment claims should be given. Perhaps even a good idea if they could brought in the English language. Unfortunately, that is not the case in my jurisdiction, but that might be something to think about. To have specialized judges which are fluent in the English language, and an annulment claim could be brought in English and could be litigated in English. That would give a lot of better access to many international law firms to do their work in that particular jurisdiction. What else comes to mind? Validity of arbitration agreements. Well, all along the lines of the New York Convention and the ancestral model law. But the detail here is important. The detail very often plays an important role if it comes to consumer protection and to employment arbitration. Now, nobody will dispute that consumers and employees, at least to a certain extent, have to be protected here because arbitration is very costly. You don't want to draw too much consumers or employees in very costly arbitrations unless you find a way to make it less costly, which again is difficult sometimes, and it's also a matter of quality. But the important thing here is, if it comes to consumer, what is the definition of a consumer? If that definition of a consumer is too broad, that might lead to many persons qualifying as consumers, which might lead to many arbitration agreements being invalid because the participation of a consumer, and that might be very bad for the place of arbitration. So not so much consumer protection is the issue, but the definition of who in what capacity acts as a consumer, and when is that not the case. A very important point in my view also, because I think it's a particular issue if it comes to arbitration in Austria. A couple of other issues which come to mind: doctrine of separability that should apply, and competence principle. So the arbitral tribunal should be in a position to decide on their own jurisdiction. And of course, again, the details here are very interesting and very relevant. If you look, for example, to the United States or to Austria or to other jurisdictions, you will learn time and again that the competence principle applies. But then if you look into the detail, you will see that details are very different. That would be something which would be an interesting investigation, international investigation at some point of time, to understand the details of how competence is dealt with in different jurisdictions. And from what I've seen so far, the outcome will be very interesting, because you will see that although many jurisdictions claim that the competence principle apply, details are so different that sometimes it's an entirely different story. So there's a lot to do for the legislator. You can see that, to make a place of arbitration more attractive. That was the first player, maybe one of the most important players here. The second player which came to my mind, equally important, are the institutions. You all know there are regional institutions and there are worldwide institutions. Doesn't make that much difference, I think, for the place of arbitration. But the institutions that are active in a place of arbitration, be they international or be they domestic or local, they have a great many influence on the quality of arbitrations, of course. Just two issues which I wanted to mention here up front, because I think these issues are right the center of current development here, is expedited arbitrations and emergency arbitrators. If it comes to expedited arbitration, if you look at the ICC rules, the ICC a couple of years ago introduced a regime of expedited arbitrations, which was, I dare to say, a huge success. Arbitrations, if they are expedited, they are much faster as a result of that, and also as an additional result of that, less costly, which is also an important thing. And for the arbitrator, an expedited arbitration also has quite some advantage, because if you, as an arbitrator, conduct an arbitration in 3 or 4 or 5 or 6 months, you probably will have to read the file once, and then you will remember what you read. You will also still remember what you've read 2 months before, when you conduct the evidentiary hearing, and you will remember what you read in the file in the first place when you write the arbitral award. If the arbitration drags along for 3 years or for 4 years, the arbitrator will have to read the file. I would have to read the file 3 or 4 times in order to refresh my recollection of what's going on. So it's also, at the end of the day, I think much more economic for professional arbitrators if arbitrations do not drag for a very long period of time, but are expedited. So from what I can see, many institutions today try to introduce or to expand their rules for expedited arbitrations. The other important issue here are emergency arbitrators, and there is a huge discussion going on of whether that is a good thing or a bad thing. I don't have the time now to deal with that in detail. I would not necessarily say that it's always a good thing to engage an emergency arbitrator, but sometimes certainly it is. It also depends on the perspective of the parties and on the situation they are in. I think it's enough to say at this point that this is something which can attribute to the quality of a place of arbitration. The participation of the players in the arbitration, of the parties' representatives in the arbitration, is something which is very important. Mostly important when I say participation is the participation in the selection, choice, and appointment of arbitrators. So from my experience, what parties to international commercial arbitration really do not want is that they are not given the possibility to appoint one arbitrator and to have at least some kind of influence on who the president of the arbitral tribunal will be. So from all my clients, the one thing I always hear when it comes to the choice of a venue is, will we be in a position, will we have an influence on the appointment of the arbitral tribunal? And if that is not the case, I think that hurts the quality of a place of arbitration tremendously. Arbitrator appointments, that's the next point I wrote on my list. Of course, from time to time, arbitrators will have to be appointed by the institution. Extremely important in my point of view, the institution has to do that in a way which makes it understandable for the parties why a particular person has been appointed as an arbitrator. So an absolute no-go, I think, for the institution to appoint members of the institution or members of the firms of members of the institution or stuff like that. So if that happens, that damages the place of arbitration tremendously, and it should never happen. At the last point, costs. Costs are always an issue. I will be very short here. I don't say that it is necessarily an attribution to the quality of a place for arbitration if the costs are low. Low arbitrator fees sometimes will also have the consequence that some arbitrators who you would like to arbitrate in that jurisdiction will not be willing to accept an appointment. If the fees are too high, that will disencourage parties to arbitrate. So it's again very important here to strike the right tone and to make this in a reasonable way. And that's the institution. I can be much shorter now for the other two players, but it's important to mention them, practitioners and law schools. And talking about practitioners, that would be local practitioners, but also international practitioners. I've already said listed here a couple of issues: legal skills, language skills. There's not much to say about that. But the important thing here is, if it comes to international practitioners, the important thing here is access to the market. So I think it tremendously hurts a place of arbitration if foreigners are not allowed to arbitrate, or if the procedure to be allowed to arbitrate in a particular jurisdiction is very cumbersome. Good example in that respect would be California. For a very long time, foreign arbitrators were not allowed to arbitrate in California. The consequence of that simply was that many international arbitrations didn't take place in California. Now that law changed, and it will be interesting to see in a couple of years whether this will attract more international commercial arbitrations to California. That's the practitioners and law schools. Last player here, and my last slide, that would be governments and infrastructure. Now, you don't need an oil rig platform as the one which I have on my slide, but that was the most infrastructure picture which I could identify when I put that presentation together yesterday. Now, infrastructure is extremely important. Airports, facilities, travel arrangements, travel possibilities. You have to be quick from the airport in the city center where the arbitration hearing will take place, stuff like that. Now, once I had put that together, I gave it a second thought, and I guess today you have to add bandwidth. Because as of today, all of us, I guess, will have experienced that. Many arbitrations will not take place physically. There's still a place of arbitration, a legal place of arbitration, but physically they will not take place in a particular location, which sometimes is a pity, and we all would like to convene for arbitral hearings, but we also know that it's not always possible, and online arbitration have become much more important than in the past. So if you would like to end bandwidth on my last slide, I think that would be a good idea to do that. And having said that, I conclude my presentation, and thank you very much for your attention. Thank you. I think you are muted, Dr. Chen. You're muted. We can't hear you.
Sorry, yeah. Okay, thank you, Sarah, for doing a great presentation from the perspective of 4 type of players. I believe it lay out a great basis for further discussion of this topic. And if any question from the audience, please write down in the chat room, and And I believe Gerold will be very happy to answer the questions during the Q&A sections. So next, let's welcome Dr. Roland Amoussou-Guenou to do his presentation. He already prepared a slide with very comprehensive perspective. So, Roland.
Yes, thank you very much, Dr. Chen. I think everybody can hear me. Yes, it's a great pleasure. It's a great pleasure. Not just a pleasure. It's a very unique privilege to be sitting at the THAC here in Bangkok, Thailand. And I believe that Céline, who is sitting just across here, is also enjoying the privilege. I will use a lot of metaphor and analogy to explain and to make my presentation. The reason is that I have invited many of our clients and also my former students, who today many of them are CEOs of important companies, and they negotiate a contract, international agreement, and I invite them to join this very important seminar. And by the way, extending our congratulations to THAC for putting together this very high-level webinar series 2020. So I will be using analogy and metaphor because I realize that by using metaphors and analogy, we refer to what we already know, and therefore that makes it easy to understand new concepts, especially for non-lawyers and non-arbitration specialists. And I would also like to take the opportunity to recognize and acknowledge distinguished colleagues and dear friends from around the world. I can cite a few names, maybe Dr. Gaston Kemfak from Cameroon and Paris is here. He's a director of the legislation in Cameroon, and he has been one of the advisors of the ICC court for many years. There is Benjamin Davis here, I think, around, and maybe Victor Smith is here. Anyway, I cannot cite everyone because I have very short time, and I will go right to my presentation. So I will share my PowerPoint presentation here. I hope it's okay. So let me walk you through my presentation. I have prepared quite comprehensive presentation, and Gerold has outlined already the perspective. Now I'll try to go a little bit more into the details. So why is the seat of arbitration so important? We start with discussing that. Then the current global competition to win the best seat status. Why is it so? And then we'll discuss the 10 legal implications of the seat of arbitration. Next will be the 4 components of the legal ecosystem of the seat. You see, I'm using the term, which is not a legal term, which is ecosystem, as a metaphor. And you will understand later why I'm using metaphor to explain the 4 components of the legal system, of the legal ecosystem. Then there is the 4 elements of the dynamic of the legal ecosystem, because again, using the metaphor, I consider arbitration as a movement. It's a motion, it's a process. So there is a dynamic and there is an ecosystem that is around that dynamic. The next topic that I will discuss will be the architecture as a metaphor. Why? I have been teaching arbitration to engineers, construction engineers. And the first challenge I met is that they could not understand legal concepts. So I try to relate to them to change the way of thinking of lawyers as the way of thinking that I have as a lawyer, to adapt, to adjust to people who think differently, especially scientists and engineers. So I came out with the concept of architecture, and you can see later why I'm talking about architecture as a block for the seat of arbitration. Then we will try to see what the legal definition of the seat is all about, because very few laws really define the seat from the legal perspective. And I will walk you through history, not too long, because if we want to understand the importance of the seat, at least the legal definition of the seat, we have to go back to history in the UK, where everything started in 1856, and you will understand why I'm talking about that also. Next will be the very interesting ICC case that I found regarding the seat. The parties have signed an agreement where they refer to the seat as China. So one party considered China as Hong Kong, and the other party considered China as the mainland. So who is right? So we discussed that. It's a very interesting case. And I would like to share a dissenting opinion about that case with you, and to share with you my perspective, and to highlight where in arbitration law, sometimes what we call the lex mercatoria, which means the body of law, which is created by the professional, can defeat national laws. And that was the case here. And I will conclude with the list of recommendations which was designed in London, what they called the London principles to create the best seat of arbitration. So this is my outline. Now let me walk you through my presentation. The topic of our session today, as proposed by THAC, is how to improve the attractiveness of the place of arbitration. And in this regard, what can be the influence of administrative, judicial, legal, also professional practices to improve the seat of arbitration? In other words, what are the actions that government could take? What are the laws that should be implemented in order to make the country more attractive as a seat of arbitration? And also, what are the initiatives that professional organizations can take, as I already referred to? For that purpose, and for the purpose of our conversation, before answering how and what to do, we need to start with why the seat is so important. Why are we discussing the seat today? Why is it important? So, what does the seat, venue of arbitration, matter? The seat matters for a very simple reason. Let me quote it that way. International arbitration doesn't sit right with a bad seat. You can see my slide now as I wrote it. International arbitration doesn't sit right with a bad seat. So the seat or place of arbitration has long been recognized as far more critical than the venue, which is the location. So in many arbitration, procedural meetings are often held remotely or in location other than the seat when this is more convenient to the parties and to the tribunal. So the seat has a range of significant legal implications. The seat is also vital because in any arbitral or arbitration proceeding, we need to determine the nationality of the award. Why? Because by knowing the nationality of the award, we can understand the link with the territoriality. If the arbitral award is a foreign award, is a national award, or is a territorial award that can be suitable for recognition and enforcement. And generally speaking, the seat of arbitration is essential because the arbitrator can use it to resolve the problem of conflict of law rules, as well as require assistance from the or control of the state judge. So it is a seat, not the site of the arbitration, which is crucial for the award to be recognized and enforced. Now, many places around the world, as we said, and Gerold also mentioned it before, are competing to become the best seat of arbitration, and what comprises a safe, convenient seat, or what is unsafe or inconvenient seat or even hot seats. I believe that, Céline, we talk about Thailand a little bit because it's not always easy for foreign arbitrator to exercise the mission in Thailand because of the requirement of work permit. And I will leave it this to Céline. So how can one be distinguished from another? For the beauty contest, again, here I'm using I'm using a comparison, beauty contest, just to relate to something more practical. So the beauty contest around the world, what needs to be done for the seat to be attractive and for the country to win the contest? In that perspective, I have identified 10 important legal implications of the seat. Let me go through these 10 legal implications. First, the validity of arbitration agreement. And Gerold has already talked about that. The validity of arbitration agreement is important because there is no arbitration without arbitration agreement. So we need to start with the validity of arbitration agreement. And if there is a seat that does not recognize the validity of arbitration agreement, the whole process will not get anywhere. Second is the acceptance of parties' autonomy and separability principle. I will not elaborate on that too much. Next will be the appointment of the arbitrators, following by the eligibility of foreign arbitrators to perform an arbitration duty. Then there is the law. The law is important because we have two main systems of law that apply and that have their own uniqueness. They have their own specifics in terms of evidence, bringing the evidence, in terms of substantial law. So the governing law is very important as well. Of course, the availability of interim measures, the possibility for assistance of the national judge, that's what I call the support judge in brackets. Next will be the risk of disruption of the national judge, which can have too much oversight. Gerold has already commented on that. The recognition and enforcement of the foreign award, which is a kind of endorsement into the national system of a foreign award, acceptance of that award and giving it the possibility, the power to be enforced. Last but not least, the condition for setting aside the award, which I call the control. So as you can see, the ecosystem that I'm using has three main components: support, oversight, endorsement, and control. So keeping the concept of the idea of metaphor, what gives life to an ecosystem is the dynamic, the underlying process, the movement. And here, let me share with you this slide, which I have created for the student who don't understand law and which will explain things very, very simply. So you can see that there is a movement, a clockwise movement that goes from the outside to the center. It's a dynamic force that starts with the arbitration agreement, then followed by the arbitration tribunal, then next by the arbitration proceedings, and goes into the center of the system, which is the arbitration award. So there is truly a force that gravitates, that moves around the arbitration award, starting with arbitration agreement. All right. So I put when everything goes well, it's green, meaning that it goes well, it's green. But all the comment that I put in red as where there are problems to be resolved. And you can see that whenever there is a problem to be resolved, there is a judge that has to come in to support, either at the beginning, which is the constitution of the arbitral tribunal, or at the setting up of the at the beginning, which is the arbitration agreement, so the discussion on the validity of the arbitration agreement. Next, if there is a problem about the constitution of the arbitral tribunal, followed by difficulties during the proceedings, And of course, when we reach the arbitral award and we have different kind of intervention by the judges, the judge that supports, the judge that bring, strength and power for the arbitration to proceed, and including helping in finding the evidence, supporting in interim measures, and so on and so forth. To make a long story short, what we can understand here is that there are two kind of forces. There is a centripetal force which goes from the exterior to the center, and if something goes wrong at the level of the arbitral award, for example, there is a discussion or a debate on the setting aside of the award, that force goes out from the center and becomes a centrifugal, which is going out of the center. So I hope that this explanation is clear enough. Now, the next slide is about the metaphor regarding the architecture. Again, I borrow this way of thinking from the student in construction in AIT. So they needed to understand very quickly. So I use a concept that they are used to. You see on this slide, down on your left-hand side, the contractual block, which relates the parties together. So the parties create what we call the arbitration agreement, the submission without which there is no arbitration. On the right-hand side, you have what I call the receptum arbitri, if we were to use the Latin concept, which is the acceptance of the duty to arbitrate by the arbitral tribunal. It is also a contract because the arbitral tribunal derives its power from the arbitration agreement. And this is a kind of contract. So when everything goes well, you have at the basis of the pyramid, the arbitral tribunal that is set up and that can start the process until the top of the pyramid, where you have the arbitral award, which has the nature of adjudication block. That's why I call it the architecture building block of the seat, of the ecosystem of the seat. After that, let's try to identify a legal definition. Legal definition, because after all, we are all lawyers and we need legal definition. The notion of seat or place is one of the most disconcerting, one of the most complex in international arbitration system. It's usually confused with site, place, forum, home, territory, jurisdiction, and so on and so forth. The complexity is compounded by the Latin expression that we use in our profession, like the lex fori, the lex or the law of the forum, or the lex loci, the law of the place, and few arbitration law have provision on the seat of arbitration, and the seat we determine the rational territory competence of the jurisdiction of the judge who will decide. So the closest expression that defines the seat of arbitration in modern arbitration system is encapsulated in the Latin expression lex loci arbitri. If you are not a lawyer, don't worry about that. It just means the law of the place where the arbitration is to take place or to be conducted. Now, after saying that, there is an impossibility to understand the notion of seat of arbitration, which is the loci arbitri, without comprehending the notion of territoriality, which means the location, the geography, the court jurisdiction, how the location of a legal act, such as a legal decision, can affect its legal status in the country where the decision is made, as well as in the foreign country where the recognition and enforcement of such decision are thought. So the analogy with state court decision is very helpful. And in that respect, let's not forget that a decision issued by judges can only be enforced because the judges have the power an authority, which we call imperium, from the sovereign state that grants that power and that authority. The question is, does the arbitrator have such power and authority? You agree with me that the answer is no. That brings us to history. Until 1996, the English court tended to be jealous of arbitration because there was a doctrine that prevailed, and the doctrine was called the doctrine of ouster. So arbitrators were perceived as rivals to be kept in the place by the judges. It started in 1854. The common law procedure has included a provision that allows arbitrators to decide in cases, but only legal cases should be referred to the courts. And following that law, that provision, there was a famous case in 1856, Scott versus Avery. In that case, the judges advanced the theory that in the principle, you cannot oust the court's jurisdiction from a contract. A party cannot contract to go to arbitration before go to court. So in other words, you can have a contract to arbitration. Only if it doesn't work, then you can go to the court. Next was in 1889. So the Arbitration Act 1889 introduced a new form of special case, meaning that parties can ask for the court to give the advice, a consultative special case. So an arbitrator might at any stage of the proceeding, under reference of the special case, refer to the court to ask for the court's advice. So from Scott and Avery, the seat of arbitration is a concept referring to the legal aspect, the legal significance of the seat. So it is clear that the seat of arbitration is a legal concept, not the geographical aspect of it. Then we have another very famous case. That case was decided in 1922. It was between Zanikov against Rod Schmidt. It was an agreement on delivery of sugar. And what is interesting in this agreement signed by the parties is that the parties agree to give power to the arbitrator to decide on fact and on law without referring to the court. And that is where the court of appeal came and said this very important statement that I think our colleagues from the UK know: there must be no Alvesia in England where the king reeks does not run, meaning that you cannot, by agreement, exclude the power of the court. So that graphic metaphor has enshrined the notion that arbitrators must stick to the law of the land. Sovereignty and territoriality must prevail over agreement. Arbitrators are allowed to decide on facts. Only judges have the power to decide on question of law, and that was known as the statement of case. Very quickly, 1950, Arbitration Act provided an appeal to the decision of the arbitrator, and the law was consolidated. And from 1978 to 1982, therefore, at that moment, criticism of the whole UK arbitration system has started by famous arbitrators and even judges. They say that statement of case allowing the party to refer to the court during the process of arbitration frustrates the agreement of the parties to resolve the problem by arbitration. So something needs to be done. And we came to the Arbitration Act 1979. That was a progress. Before Arbitration Act 1996 was approved after the New York the UNCITRAL model law of 1985, which was a little bit incorporated in the Arbitration Act of UK 1996. So these are the historical roots for the legal definition of the seat. Now, what are the reasons why in UK, there was that movement to improve the seat, the law of the seat? The first reason is economy, because from 70s and later on, there are new arbitration cases that started to emerge, and different from the traditional arbitration that used to go to London. And ICC started to become more and more popular. So practitioners in London didn't want to see all those business leave London to go to Paris. And as a matter of fact, it was estimated that more than £500,000 were lost every year because of the law of the UK, and that needed to be resolved. The next topic I would like to discuss with you now is a recent case, ICC case. It was a case between two companies, Z and A. Let's just anonymize the name. Signing agreement, and the arbitration agreement referred to arbitration in China. So what happened is, the party A started the arbitration by identifying China as Hong Kong. Party Z took the opposite view, that the place of arbitration was mainland China. So, following the parties' disagreement on the place of arbitration, the ICC court fixed the arbitration to Hong Kong, using the powers that are in the rules of the ICC. Following that, the arbitration tribunal upheld the seat as being Hong Kong. Of course, the other party didn't agree and went to the court in Hong Kong, and the judge in Hong Kong confirmed that it was Hong Kong. So the reason is very interesting, and that reason is outlined in the bottom of my slide, and let me quote it for you because it's very interesting. That was a statement of the judge. On such basis, and bearing in mind that the object of arbitration agreement must be to have the dispute resolved by a process which will result in a final and binding and enforceable award, I would agree with the arbitrators that the arbitration between the parties in this case should be conducted in Hong Kong. All right. Now, let me take 1 or 2 minutes to complete and to conclude on that my presentation with a dissenting opinion regarding that arbitration, that ICC arbitration case. The dissenting opinion is what? In the Chinese definition of China, which is pronounced Chongguo, and in that instance, I'm speaking under the control of Dr. Chen because my Chinese is not that perfect. So China is Chongguo. So the sovereignty doesn't apply to the territory, but to the central state, which is the mainland, which is pronounced Chongguo Dalu, which is the big mainland of China. Arbitration seat, which is pronounced Chong Sai Di, the seat of arbitration, shall consequently refer to Chongguo Dalu, not to the territory of Hong Kong. And the arbitrator, Chong Tsai Ren, is bound by the law to apply the Chongguo Dalu law. Moreover, Hong Kong is not directly a signatory of the New York Convention, since China was a signatory of the convention since 1987 and has extended the convention to Hong Kong in 1997. So this is how politics, business interests, and lex mercatoria can affect international law of arbitration, the implication can be very important. Why? Because mainland China is a civil law system, while Hong Kong is a common law system. And those laws can have very tangible, very practical effect in regard of the language, evidence, and even cost. And those discrepancies have to be taken into consideration. Let me conclude now with the London Principles. The London Principles were adopted in 2015, only 5 years ago, by the Chartered Institute of Arbitrators as a framework to develop the best arbitration seats. It's called London Principles. That's very interesting because more than 200 years later, after the Scott and Avery case, we are back to London. So those are the principles. First, an arbitration law providing a good framework for the process, limiting court intervention, and striking a good balance between confidentiality and transparency. Next is the independent, competent, and legal profession. Gerold has already elaborated on that. A sound legal education system. Again, Gerold has outlined this point. The right to choose one's legal representative, ready access to the country for witness and counsel and safe environment, good logistical support, professional norm embracing a diversity of legal and cultural tradition and ethical principles, well-functioning venues, adherence to treaties for the recognition and enforcement of foreign award and recognition of arbitration agreement, and last but not least, and my favorite, is the immunity for arbitrators from civil liability for anything done or omitted to be done in good faith in the conduct of the mission as arbitrator. I don't know how many countries in the world or regulation will accept the immunity of arbitrators, but this is a very interesting development. So with that, I would like to thank you all for your attention, and again recognize all the friends and clients that have joined this webinar. And if there is any question, I will be very happy to answer by interacting with you. Kokung Kap, thank you very much.
Okay, thank you, Roland, for doing a very comprehensive and deep introduction of this topic. And Roland also shared some interesting case about the seat of arbitration. He even mentioned the ICC case related to China. Just a few remarks on the background. Actually, one main reason that the arbitral tribunal in the Hong Kong court support the interpretation that the seat of arbitration, the seat of China could be interpreted as the city in Hong Kong is just because at that time, actually the Chinese court system is not very clear on the validity of the arbitration seated arbitration administered by foreign arbitration institutions in city in China. If this case happened now, actually, I think the results could be different because currently the Chinese court actually basically will support the validity of the arbitration agreement, which administered by foreign arbitration institutions in the city in China. So we may talk about this more during the Q&A sections. So now let's move to the next speaker, Céline. Because Céline has the background of working in arbitration institutions, she will share with us more detailed observations on this topic.
Thank you very much. Let's talk a little bit about what.
It could be louder, Céline.
Can you hear me? Can you hear me?
A little bit.
Fine. Sorry about that. So what I'm going to talk about what does an arbitral institution or arbitral tribunal when fixing the place of arbitration before talking about Thailand. Yes. So let's examine briefly the issue of the place of arbitration from the perspective of the arbitral tribunal or the arbitral institution. So first of all, as you know, the institution or the arbitral tribunal only take a decision when the parties fail to agree on the place of arbitration. So let me just, sorry about that. So in most of the time, the parties agree on the place of arbitration. And as it's only when the parties disagree, as for instance, the ICC rules provide and the CF rules are musical. So the CF rules and musical. Oh, sorry about that. I just need to change the microphone. Okay. Okay, sorry about that. So under the unit rule and CIAC rules, it is the arbitral tribunal who is going to be in charge of fixing the place of arbitration if the parties fail to agree, while under the ICC rules, it is for the ICC court to take a decision in this regard. So let's talk briefly about what factors does the ICC consider when fixing the place of arbitration. So of course, the first criteria and most important criteria is that the place is an arbitration-friendly place of arbitration. So this is because for the ICC, it's very important to make sure that the award will be enforceable. So what does it mean? Well, the ICC will look at the arbitration law of the place of arbitration, of course, and wherever possible, it will choose a country which is a signatory to the New York Convention, and a country which has a modern, effective, and accessible international arbitration law, and supported by experienced courts, which is a very important point, obviously. And especially the ICC preferably doesn't want to fix the place of arbitration in a country where there is inappropriate court interference with the arbitration. So that's why it's even more important for state authorities to improve the attractiveness of the place of arbitration as safe and arbitration friendly to attract more to convince investors and arbitral tribunals and institutions to fix their country as the place of arbitration. And then the other factors are the neutrality that the ICC considers are neutrality. So the ICC wants to find and fix a place of arbitration which is neutral for both parties, and regarding the parties' nationalities. So no party shall have an advantage over the other because of the place of arbitration. So if both parties are if one party is from a country, then the ICC will prefer not to fix the place of arbitration in that country, but it really depends on, it's of course a case-by-case basis. And then the ICC will also consider the location of the parties and the parties' counsel, and the place needs to be geographically convenient and accessible to all parties and their counsel. And then lastly, the ICC might consider whether in this place of arbitration there exists some good facilities for the hearings and for the arbitration to take place. So let me just, I wanted to talk about an example of parallel judicial proceedings in which I was involved, just to give you an idea of what could happen and what we don't want to happen. So it was an institutional arbitration case. And during the arbitration, so after being joined to the arbitration as additional parties, such additional parties brought a tort action before a judicial civil court in the country of the place of arbitration. Against the action, the tort action was brought against the other party, and was brought also against the employees from the arbitral institution in their personal capacity. So the arguments of the additional parties were that the employees of the arbitral institution committed a tortious act and gross negligence by joining them to the arbitration in bad faith and in a way inconsistent with the institution's arbitration rules, and which caused them allegedly damages. So it was very, of course, problematic for the defendants in those cases, the employees of the arbitral institution, because they had to go before the local courts, and defend themselves while they were just acting as employees of the institution when working on the case. So the employees of the arbitral institution's arguments were that the court was not competent, the judicial court was not competent, as it related to actions which took place abroad and did not take place in the country of the place of arbitration. And then also they argued that they, of course, did not act in bad faith or with no intention to cause injury, and they only conducted their professional duties in strict compliance with the institution's arbitration rules. So what was the result? Well, fortunately, the civil court denied the claims, but it was, as you can imagine, very stressful and not very nice for the employees of that institution to be brought before the local courts of the country of the place of arbitration in that case. And so I would say that knowing that the employees of an arbitral institution can be sued at the place of arbitration in their personal capacity for performing their professional duties can deter investors, and in particular arbitral institutions, to choose that country as a place of arbitration. So, well, I would imagine that the institution may think twice next time before fixing that place of arbitration in another case. So let's talk also briefly now about Thailand. What's the situation in Thailand? So I'm not a specialist of Thailand, so if don't hesitate to interrupt and correct me if I'm wrong. So what is going on in Thailand, and what can be improved? So as you may be aware, the first issue is that for foreign arbitrators and counsel who want to act in arbitration seated in Thailand, they need to obtain a work permit. So, but then the situation evolved, because before what happened was that the arbitrators were required to go through a tedious process to get a work permit to act in arbitrations in Thailand. And the foreign counsels who wanted to act in an arbitration seated in Thailand were actually prohibited from acting in arbitrations in Thailand, where the dispute was governed by Thai law, or the award would be enforced in Thailand. So in a way, you can understand that this did not really encourage people to select Bangkok or Thailand as the place of arbitration. Well, fortunately, things have evolved. And now there has been an amendment in 2019, an amendment to the 2002 Arbitration Act, Thailand Arbitration Act. And now the procedure is easier for foreign arbitrators and party representatives to get a work permit in order to be able to act in our arbitration seated in Thailand. So what happens is that they can request a certificate from one of the two Thai arbitral institutions, which are TAI, Thailand Arbitration Institute, and THAC, Thailand Arbitration Center. So they can request them a certificate to be used to support their work permit application to Thai immigration. So they still need to obtain a work permit, but the process is much easier than it used to be. And the work permit, once they obtain it, will allow them to reside in Thailand and work on this specific case for the time specified in the certificate. And they can actually start working on the arbitration case, even though the work permit application is pending. So it's a good sign for arbitration in Thailand. So now let's maybe talk about briefly the what is the status of case law in Thailand and the court's intervention and the court's intervention after the award is rendered. So, of course, as we have talked about earlier, case law is very important to understand in order to understand whether a country is arbitration friendly and whether it is safe to choose that country as the place of arbitration. And in the case of Thailand, there has been some improvements. So regarding the award, of course, you can, once you have the award in Thailand, you can either challenge the award or try to enforce it. So if you want to challenge the award, well, a losing respondent party often challenges the award before judicial courts on the usual grounds of violation of public policy, invalidity of the arbitration agreement, or violation of due process. And when you try to enforce an award, so you also go before Thai judicial courts, and a Thai court may refuse enforcement of the award on one of the 6 usual grounds of the New York Convention. But a Thai court might also refuse enforcement if it considers that the dispute was not capable of being settled by arbitration under Thai law, or that enforcement would contravene public order or good morals of the people. And usually Thai courts tend to apply these grounds pretty fairly, but the public policy ground can sometimes be interpreted quite broadly, and especially in cases where state entities are involved. So let me give you 2 short examples where Thai judicial courts have either annulled an award or refused to enforce an award, just to give you just 2 examples. So the first case is, it's called the ITV case from 2006. It's a decision from the Supreme Administrative Court in Thailand. So what happened is that, so it was an enforcement case. So a party tried to enforce an award, but the court ruled that the provision of the amended concession agreement between private company ITV and the Thai government did not comply with government regulations and was therefore not legally binding. So what happened is that the court refused to enforce the award, as it was a decision based on allegations of breach of contract, which would be, according to that court, invalid. And so the court found that enforcement of the award would thus contravene public order and good morals of the people. So you see that this can be, in a way, problematic. So it's good to know in advance what's the how the local courts might interpret the law when trying to enforce an award. Then let's talk briefly about a second case, which is a quite famous case in Thailand. It's called the Hopewell case. So in this arbitration, what happened is that there was a contract from the 1990s, between Thai authorities and Hopewell, which was a Hong Kong-based company. And it was a contract to build a highway and railway between Bangkok and Don Mueang Airport. While the construction ended and the Thai authorities terminated the contract in 1998 before the project was completed. So the private company Hopewell started in 2004, started an arbitration against the Thai Ministry of Transport and State Railway of Thailand. Well, then the tribunal was constituted. The arbitral tribunal found in favor of Hopewell, of the private company, and ruled that its claims were not time-barred because the dispute arose in 1998. And the tribunal applied the 10-year limitation period, which is applicable to general contract claims. Well, in that case, there was a challenge to the award before Thai courts, and Thailand's Central Administrative Court ruled that it was an administrative contract, and it actually the court actually applied retroactively a 5-year prescription period under new law, which was enacted in 1999. Well, and this law entered into effect after the dispute arose, since the dispute arose in 1998. So you can imagine the problem, because then the court annulled the award on the basis that the claim was barred by prescription. So, and it was a retroactive application of a law. So you can imagine that it was kind of problematic to have an award annulled on that basis. Well, fortunately, Hopewell appealed the decision. And on 21st March 2019, so pretty recently, the Thailand Supreme Administrative Court overturned the decision of the Central Administrative Court and ruled that the new law could not have, the new law of 1999 could not have a retroactive effect since it came into effect in 1999, i.e. after the dispute arose. So the court reinstated the award and ordered the Ministry of Transport and State Railway of Thailand to comply with it. So it's a good, so this decision is a good sign towards a more arbitration-friendly approach of Thai judicial courts. And just to finish, what would be the areas for improvement in Thailand to make Thailand a more attractive place of arbitration? Well, there are many things that could be done, but I would say that one of the areas to improve would be to limit guerrilla tactics. Well, guerrilla tactics, of course, exist everywhere. But of course, the guerrilla tactic would be to challenge the appointment of the tribunal, or to challenge the arbitration agreement before the local courts, the Thai local courts, with so those parallel judicial proceedings in order to delay the arbitration proceedings. Another way would be also, another option would be to set up a specialized court, judicial court, which would be in charge of dealing with all these arbitration-related issues before Thai courts, in order, for instance, first of all, to reduce the delays of the annulment proceedings in Thailand, and also to have judges who are familiar with arbitration and familiar with arbitration issues and who know exactly how it works. And in that sense, I would say that I replied to one of the questions that I saw from Vanina Sutadkul. I would say that, for instance, TAC, or the Thailand arbitral institutions, could also work towards maybe working together with Thai judges to have some, I would say maybe some trainings and something put in place to help maybe set up this specialized court to deal specifically with the arbitration-related court proceedings. And then the last one other option would be to eliminate the requirement of a pre-entry visa prior to entering the country for foreign representatives and arbitrators, which is, I mean, it's, and this is different from the work permit, but at least like the work permit issue was very problematic for foreign arbitrators and representatives to come work in Thailand on arbitration seated in Thailand, but then it had evolved. And then if also this pre-entry visa requirement would be eliminated, that would also, I would say, help to make Thailand more attractive place of arbitration. But I think we're getting there in Thailand, and there's been some good improvements. So thank you very much for your attention, and I look forward if you have any questions to ask me. Thank you.
Okay, thank you, Céline, for sharing us the insiders' view of our observations on the factors that the ICC considers when fixing the place of arbitration, and then introduce the interesting case law from the Thai judicial courts, and also offer the sections to improve its attractiveness of Thailand as a place of arbitration. I believe it will be very helpful for the potential users. And before going to Q&A sections, I also would like to do a very brief introduction on how China working to improve its attractiveness as a place of arbitration in recent years. I believe it might be you're interested to most of the audience. So first is an overview of arbitration in China. Okay. The Chinese arbitration law came into force in 1995, and by the end of last year, there are 253 arbitration institutions in mainland China. And the cumulated case load from 1995 to last year is over 3 million cases. So, and this is the annual case load over the last 10 years. It reached a record high number in 2008. It is over 500,000 cases 1 year. And this is the annual amount in disputes over the last 10 years. It reached a record high number in 2019. And this is the foreign-related cases over the last 10 years. And foreign-related is the expression of international under Chinese law. And one thing unique is actually for the disputing parties related to FIE, foreign investment entities, under Chinese law, it was the case will be regarded as domestic cases rather than foreign-related cases under Chinese law. So, and next I will introduce some recent developments in creating an arbitration-friendly environment in China. The first in-depth development is from the Supreme Court in 2016. In this opinion from Supreme Court, it broadened the scrutiny of foreign evidence test. As I mentioned earlier, in the past, for the entities registered under Chinese law will be the dispute between them or involve them will be regarded as domestic cases. But now in these documents, if the a wholly foreign-owned enterprise registered in the free trade zones, and then it will be regarded as have the foreign elements in that the arbitration related to them will be regarded as the foreign related cases. And also indirectly allowing the ad hoc arbitration, under the 1995 arbitration law, only allowing the institutional arbitrations. But in this document, that the enterprise registered in free trade zones, they could agree to do the ad hoc arbitration. The second development is from the Shanghai Municipal Bureau of Justice. As I mentioned, on response to the case, the ICC case mentioned by Roland, actually in the past, the foreign arbitration institutions are not allowing to provide arbitration service sitting in China. So, but in these documents, actually, they substantially opening the arbitration market, and now they allow the Shanghai allowing the foreign arbitration institutions to open their business office rather than liaison office in Shanghai into offering the arbitration service substantially. That means they could accept the cases in hearing and awarding the case in Shanghai, in city in China. The third development is also from the notice issued by Supreme Court. In the past, in China, the judicial review on the domestic cases in international cases or foreign related cases is by the different trial divisions. And now since 2017, now all the cases, whether they are domestic or foreign related, they will be reviewed by the trial handling foreign related commercial matters. So this was regarded as a plus for the competency and consistency in arbitration related matters. And also the Supreme Court expanding the report for approving mechanism. As some of the friends may note, since 1995, for foreign award and foreign related award, actually if the Chinese court would like to not enforce or set aside the award, they should submit it to for approval from the Supreme Court. And this mechanism was regarded as a grace protection on the arbitration, but in the past it is not applied to domestic cases. Since 2017, this mechanism also applies to domestic cases. That means in China, it's very difficult to set aside or or refuse to enforce an arbitral award. In the next development is about the competent court to enforce the award. Actually, if you'd like to enforce an award, you could go to the intermediate court rather than to the grassroots court or the basic court. In China, you know, the higher level of court means more competency and could avoid the local protections. And the time limit for ruling or for is very limited. That means for a case not to enforce the arbitration award, the court shall conclude its examination in make a ruling within 2 months of the case being filed. So it's only with the limited extension by 1 month. So it would be very helpful for the disputing parties to achieve the goal of high efficiency. In the next development is the the CICC, China International Commercial Court. So the there are many key features of CICC procedures. I don't go into details, but the key features is one-stop international commercial dispute resolution mechanism. That means the CICC set up an international commercial expert committee in select international commercial mediation institutions and international commercial arbitration institutions that meet certain conditions to build up together with the CICC, a dispute resolution platform on which mediation, arbitration, and litigation are efficiently linked, so thereby create a one-stop international commercial dispute resolution mechanism. And BAC was one of the 5 arbitration institutions in this list. So what's the benefit to be listed in the one-stop mechanism of CICC? The main benefit is the parties can apply for the preservation orders before and during arbitration proceedings from the CICC. And also, the parties can apply for setting aside or enforce the International Commercial Arbitration Award from the CICC. That means if the arbitration institution is in the list of CICC, you could have the judicial support from the CICC. That is actually the Supreme Court level in China. Let's move to the expert from arbitration institutions in creating the arbitration-friendly environment. I will take BAC as an example. BAC established in 1995, and this is the annual case law over the last 10 years. It reached a record high number in 2019. It's 6,732. This is the annual amount in disputes. Also has a very increasing trend. And this is the international case load. And last year is 163 international cases, with disputing parties coming from more than 30 countries. And there are 526 appointments going to arbitrators without Chinese nationality from 2005 to 2019 at BAC. If you care about the gender distributions, we have around 40% of the appointments going to female arbitrators. This is substantially higher than most of the arbitration institutions. And BAC keep revising its rules to meet the international standards, so that the council, the foreign council, can argue their case before BAC, like they argue the case in any other international arbitration centers. So the significant changes in the last 2 revision could be clarified into 2 aspects. First is to better meet the expectations of international users. There are some revision on the seat of arbitration, language arbitration, applicable law, interim measures, emergency arbitrators, in calculation method of arbitrators' fees. For example, in the past, if both parties has not agree upon the seat of arbitration, by default, the seat of arbitration would be China. But now, under the new rules, the default seat of arbitration will not be China. Actually, the BAC may make a determination by taking into account the circumstance of the cases and choose any jurisdiction, including one outside of China, like in Thailand or Vietnam or any other place. And also to better meet the needs of handling complex disputes, there are specific provisions on the claims between multiple parties, joinder of additional parties, consolidation, single arbitration under multiple contracts, etc. So from all I have introduced several conclusions. First, the growing number of arbitration cases in amount in disputes reflect it in the statistics, point to a clear increasing demand for arbitration in China. Second, the Chinese judiciary has assumed a highly supportive position on arbitration in creating an arbitration-friendly environment. Last, with the revision of arbitration rules, top Chinese arbitration institutions continue to improve its ability to provide dispute resolution service that meet the international standards. So this is my sharing on some information related to the arbitration in China. Hope it would be of help for any potential users or when you're negotiating with Chinese parties on the field of arbitration. So now let's move to the Q&A section. I know there are several questions from the audience, and also Roland already answered some of the questions, right? So let's go to the first questions. So first question is to Roland about the in your slide you mentioned arbitration seat and venue. Is that the same? So are the venue and seat the same legal concept, or they can be distinguished? So Roland, would you like to answer these questions, or you already answer in written words? I can see it there. No sounds.
Thank you, Dr. Chen. Yes, I've been answering yes on the fly while the question were being sent to me. So I say that the seat is really a legal concept. The venue is related to the location. It's related to the geography where the operation are being are taking place. Let me give the example of this session. If this session at THAC was an arbitration, Céline and I would be at the seat, which is a THAC, which is in Bangkok, the seat that have the control, that have the power to organize it, and that has all the logistic here to control it. But you are in China right now, in Beijing, I believe, and Gerold is in Austria, and we are all participating in the same session, but they are not at they are not at the venue. They are at the seat. We are all at the seat because we are all having the session organized by THAC, which is the seat, if it was an arbitration. But the venue is different. So the venue is more related to the location, and the seat is a place, is the legal, the legal concept that we have explained already, which is the ecosystem, which is where the activities have legal consequences, a legal implication for the process. So the seat is different from the venue. I hope I have answered properly.
Okay, thank you, Roland, for your clarification. And the second question is about how can Thailand become a more arbitration-friendly circumstances? So I believe Céline already answered a little bit during her presentations, and I know both Céline and Roland based in Thailand. So would both of you have something more to add on this question?
Yes, I would just add concerning the guerrilla tactics and the challenges to arbitrators, that maybe one way would be also to have the arbitral institutions have some parties pay when they challenge arbitrators, because then it would avoid some frivolous challenges. And so that's all that I wanted to add, because I've talked about the other suggestions earlier, but Roland, if you have anything to add concerning Thailand.
Well, Thailand is could take advantage of many assets that I believe the lawmakers or policymakers are not really capitalizing on. For example, the hospitality of Thai people, the infrastructure is very good. We have quite a good bandwidth, and the technology works quite good here. And last but not least, we have THAC now. I don't know how many of you have visited the premises of THAC. It's a very modern, venue with beautiful offices, meeting rooms. Technology works well. You have break-up rooms. You have a very competent staff. So I believe that from the logistical perspective, Thailand has very good assets that are not being optimized, maybe because the policymakers and the lawmakers didn't realize or didn't understand the true essence of arbitration as a tool at the disposal of the business community to resolve their problem. Singapore has realized that, and they have created a very, arbitration-friendly environment, laws, and Singapore International Arbitration Center has a very progressive arbitration rules. So what needs to be done is really modernize some of the rules. For example, Thai Arbitration Institute, for me, need to improve because it's related to the judiciary. I don't know if there is any other country in the world where the Arbitration Institute is directly under the supervision of the judiciary, Ministry of Justice. So there is, I think, an understanding of arbitration as something, a service providing for the business community, which is different from justice as is understood under the state system. But it is improving, and our presence today is a testimony of a progress that, an organization like THAC is putting together such an international training program, webinars to educate people, to raise awareness, and it's happening slowly, but it's happening effectively. We need to be patient.
And if I could just add also, more generally, I would say that in Thailand, if more people are trained about arbitration, then there would be more Thai lawyers who know also about arbitration. I mean, of course, there are many, but I'm sure that there could be much more. And also concerning the what I said earlier about the judges, and maybe there could be some trainings and more discussions with the authorities or the judiciary, just for them to understand that arbitration is not a threat to the judiciary. And I would say that also some cases which go to the judiciary, to the state courts, wouldn't go to arbitration, and the other way around. So it's not a competition between those two dispute resolution mechanisms, and to have more people know and be trained about arbitration would help everyone, and would help also the progress of arbitration law and the Thai arbitration law evolve. But as Roland said, there has been some good improvements, and that's why we look forward to knowing what the future years will bring in Thailand for arbitration.
If I may just add one more thing, I think there is one of our colleagues in the audience, Victor Smith, is a member of the ICC Thailand and also belongs to the ICC Thailand committee here in Bangkok. He has led a very good battle, because thanks to Victor Smith, that now we have the law that allows foreign arbitrators to be able to operate in Thailand with a work permit, and that is something that is an achievement that has to be credited to Victor Smith.
Okay, thank you, Céline and Roland. And considering the choice of seat, actually, for the forum or for the seat in Europe, traditionally, at least from the perspective of Chinese users, usually they will go to Paris, London, Stockholm. So since Gerold was from Vienna, so may I invite Gerold to share some views on or provide some suggestions for the potential users whether they should consider Vienna as a seat of arbitration.
Of course, I'm practicing from Vienna, which means, in my view, Vienna must be the best place of arbitration you can go to, possibly. But more seriously, there are, I guess, a couple of very prominent seats of arbitrations in Europe. So if there is a general decision by the parties to make a European place as their place of arbitration, I mean, a lot of places come to my mind, of course, including Vienna, but also Zurich, of course, Paris, of course, London, of course, places in Scandinavian countries. And I'm sure I now forgot to mention one or two places which would also be very, very convenient. The most important aspect here is access to the arbitration law, I guess, in particular for the arbitrators, but also for party counsel. So it's a very, very positive if the arbitration law has been drafted along the lines of the arbitral model law, because that makes it easier for everyone. Even if that is not the case, at least there should be an English language version of the arbitration law available, and possibly also one or two good commentaries on the law in English language, so that everybody has the same access. If that is a given, I'd say Zurich, as Vienna, as Paris, as many other places in Europe are as good as it gets, and the parties will freely choose between them. Perhaps driven more by convenience than by the law, because some of the witnesses are already in Geneva, for example, then it makes a lot of sense to have the hearing there. Once you have the hearing there, it will also make a lot of sense to have the place of arbitration there. And that goes for Vienna as well as for London, as well as for any other venue in Europe.
Okay, thank you, Gerold, for sharing your insights. And now we have 5 minutes left, so we'll go quickly. The next question is, should the seat of arbitration determine the date in hearing of an arbitration online when there are arguments between parties on time zone difference? I find Roland already answered this question in written. So if Gerold and Céline has something more to add? If not, we'll go to next questions.
Perhaps very, very briefly, and I would see this also as a very practical matter, because if there is a physical hearing, all the parties will be on the same place. That means they will be in the same time zone. And if that is not the case, if that is an online hearing, then it becomes automatically a very practical matter, because I think it's not acceptable that the hearing will start at 9 a.m. for one party, but for the other party it will be 2 o'clock in the morning. So it will be necessary to find a time which is convenient for all parties. Add a couple of witnesses to be cross-examined, which might be in different time zones, and you can easily imagine how difficult that task may be. And it may also call for perhaps interrupted hearings of just 3 or 4 hours, and then there would be a break of 10 hours, and then you would have to move on to make it somehow work in a way that witnesses, expert witnesses, and parties and arbitrators are all in their individual time zone at a time of the day where it is convenient for them to participate in an arbitration hearing. Practically, it might be very difficult to do that.
Mm-hmm. Agree with that, yeah. So, Céline, do you have any idea on these questions?
Nothing particular to add on this question. Thank you.
Okay. Now let's move to the next question. is how much the institutional fee influence the choice of the seat of arbitration, and what about the institutions available in the country? So Roland already answer in written. So would Céline and Gerold have something to add?
Yes, I would say, of course, the costs of arbitration are really one of the criteria, of course, and for instance, you can see that there's been more and more regional arbitration centers, which have started to compete with all the global arbitral institutions. So, of course, if you can have a cheaper arbitration with the local center, with the place of arbitration, then as a lawyer, I would advise my clients to choose that arbitral institution for the place of arbitration, but provided that the place of arbitration is arbitration friendly and that the arbitral institution has experience and has some cases, and that you have had some good experience with this institution.
Might I
Thank you.
Might I just argue to the contrary here, just for the sake of argumentation, and also because I think there is a point to be made of it. There is some empirical data which neatly demonstrates that the cost of representation, so the lawyer's fees in arbitration, on the average are 5 times the arbitrator's fees. So if you look at that, the difference between fees paid with the LCIA, which may be a little bit at the higher end, the VIAC, which may be a little bit of the lower end, the ICC somewhere in the middle, doesn't make much difference if you pay 5 times as much for party counsel. So I do not believe that the choice of the institution makes much difference in the overall costs of the arbitration proceedings.
I would add also, it depends. I mean, of course, the lawyer's fees are much, much higher than the arbitrator's fees and the institution's fees. But I would say also it depends on the type of case you have. So if you have a very high stake arbitration, then of course, it wouldn't make a huge difference. But on the contrary, if you have a very small case, and I've seen that very often when I was working for the ICC, that with the small cases, the fees, even of the arbitrators and of the institution, can be very high, and so I would say it would make a difference for smaller cases than high amount cases.
Okay, I find one question to Dr. Roland. Is what African countries especially belong to OHADA zones, where a lot of what? If investors can do to improve their attractiveness as a place of arbitration? So Roland, could you understand the question and answer it?
Okay. Well, I would like to thank the person who asked the question, and I can imagine who he is. Yes, I think to share the insight regarding this question, I need to say, what is OHADA? What does it mean? The OHADA is a very unique organization called Organization for Harmonization of Business Law in Africa. That was created bringing together 17 African countries today. And that is very important because it's a first step to create a common space, a common business space where the business players from different countries and coming from different legal systems and different legal heritage can harmonize the interpretation and application of the business law. And there is a number of business law, and including arbitration. That was the uniqueness of that, that legal harmonization that happened in 1993. So there is an arbitration law, and there is an arbitration court that was established in Abidjan, Côte d'Ivoire, which is a common court of justice and arbitration. This is very important because that harmonization itself is a very big step to improve the legal environment for arbitration in Africa, because each country before has its own arbitration law, and there are different interpretations, and they speak the same language, they have the same Francophone or French legal heritage. So business and investment has a lot of difficulty to go from country to country. So the harmonization was a very good thing. And the harmonization of the arbitration law was also a very good thing. But even more than that, they have a one-stop arbitration center that looks at the arbitration cases, which is based in one country under the treaty. And this is very good. Now, what needs to be done is like anywhere else. It's about education. It's about training the young lawyers to be familiar with arbitration procedure, to know how to negotiate arbitration agreement so that the arbitration agreement is not pathological, that it can be executed, that the procedure can flow through the constitution of the arbitration tribunal to the process until the arbitration award is issued and enforced. So there is also a school. The founder of the HOADA, they have done a very good job, because not only they created a unique court that can look at the implementation or the enforcement of the award, they also created a school in Benin, I believe, in Benin, and it's called El Suma. And all lawyers are trained in ESUMA, to become expert in international arbitration. And I can tell you that in 15 years now, there is really a new generation of African lawyers who are very good in international arbitration, and they communicate with me. I am here in Asia, but I also connect with my friend and my former colleague in Africa. And by the way, as you are in China, you know that China is investing heavily in Africa through the Belt and Road, initiative. And that initiative really comes, timely with the OHADA, because the legal framework was already set to help and facilitate the Chinese investment in Africa. And arbitration agreement also, include the OHADA when the implementation is happening in one of the OHADA countries. And last but not least, most of other countries are also signatory of the New York Convention and also of the Washington Convention. So from the legal perspective and the legal framework perspective, Africa really offers the best possible legal environment for arbitration to prosper. What needs to be done is infrastructure, improvement of infrastructure, improvement of communication, safety, and education of arbitration counsels and arbitrators. I hope I have answered the question.
Yes, thank you, Roland. Great answers. Actually, one information to add, Beijing Arbitration Commission with some arbitration institutions in Africa, like OHADA, we have created a China-African Joint Arbitration Center. It is a platform to promote the use of arbitration in the transactions relating to Chinese and African parties. And the last question is obvious for me. That is, can foreign arbitrators in foreign councils participate in arbitration proceedings in China without a working permit? The answer is yes. Actually, for the foreign councils and foreign arbitrators, they can not only participate in international cases administered by Chinese arbitration institutions, they also can participate in domestic cases. The only limit for the foreign counsel is they are not allowed to interpret Chinese law. If they are related to issues about Chinese law, they may cooperate with local counsel or introduce an expert opinions. So since we already run out of time, so before wrapping up this webinar, I would like to thank the three speakers for your great experience, and also thank all the participants for your attentions. And last but not least, let's thank the THAC, especially for the Ms. Benyapa Reckerwelt for her excellent organizations to make this webinar possible. So thank you all.
Thank you.
Thank you. Kokungkap.
Thank you very much.
Thank you very much. Goodbye.
Thank you.